something you're a bit more expert on. A good story, this one. Bank charges. First, a few years ago, overdraft fees were big news. You remember that? The Office for Fair Trading wanted to take the banks to task for charging excessive overdraft fees. That's because there were so many individual cases out and around that they wanted to sort of grab them all and unify them. However, a Supreme Court ruling in 2009 stopped the OFT in its tracks. Because of that, the Supreme Court ruling, no one has been able to challenge overdraft fees in the courts since then, many years ago. Until now, that is. Last month, a 28-year-old man from Somerset became the first person to win a bank charges case in court since 2007. Unbelievable, that. Oliver Foster-Burnell won his case against Lloyds TSB, as it was then, at Taunton County Court last month and successfully reclaimed £743 plus interest in overdraft charges and was awarded an additional £1,000 in damages. And now, even though he's won, he's appealing the decision. He wants more. Let's talk to Ollie Foster-Burnell and his solicitor Kate Briscoe from Howlett Clarke. Welcome both.
Hello.
Ollie, amazing. I mean, when you started this, did you realise you were such a trailblazer that hadn't been done for a while?
I realised it hadn't been done for a while, but I kind of felt the sense of injustice, so I wanted to take it forward anyway.
Tell us about why you felt aggrieved.
I suffered financial hardship a few years ago, and I went something like £2.75 over my overdraft, and as a result of that, Lloyds were charging me up to £20 a day, which resulted in about £330 over 2 months.
So this is, just to be clear, you went to just, £2.50 or something over your agreed overdraft?
That's
correct,
that right?
Yes. So
yeah.
you went into the unagreed territory, if you want.
Yeah, that's right.
Okay.
And I had a temporary drop in income, which Lloyds were aware of, and they wouldn't offer me any sort of ground to help me try and recover that myself. So they just continued charging.
And this was charges. Let's be really clear, because a lot of people say, well, it's your own fault. You went beyond there. But what happens is the systems, and they have improved, are designed to entrap. You get charges on charges on charges that snowball. And then you can't afford to rescue yourself because of the charges. Is that your situation?
That is my situation. And that caused a snowball with other creditors as well, because that was my main bank at the time until I followed the forum sort of guides on opening a parachute account. And
just tell us, Ollie, about those other creditors. So tell us how it affected other areas of your life.
Well, because I had a drop in income and that those charges were being applied, those charges were swallowing up quite a proportion of my income, and so then I may not have had enough money in some months to actually pay my credit cards and other things, so then they were charging me as well, and so I was just getting into this spiral situation which was ever so difficult to sort of pull myself out of.
All because of £2.50?
Yeah. So
then how did you, so then this happened to you when?
Back in 2008.
Okay, so that was... you were then sort of the last few years, you knew that no one was taking anyone to court.
Well, remember, in 2008, we were in the midst of this. This was in the time that we were going forward and we were, the OFT finally agreed to take on the case that those of us had been campaigning on it for years beforehand. And we, won in the High Court, we won in the Court of Appeal, and then... And on a technicality, what the Supreme Court said, and it's very important people understand this, they did not say that bank charges are fair. They said that bank charges didn't fall under fairness rules. And in fact, in the judgment, they were quite deliberately made sort of nods towards the fact that bank charges weren't fair, but that under the rule, this particular rule that had been tried, they didn't have to be fair. And what it is effectively, what they said is, they decided that bank charges were a price. They were part of the price, and prices don't have to be fair. Now, what we had all argued is they weren't. They were an ancillary charge that wasn't part of the main price, and therefore they should have been fair. And the High Court and the Court of Appeal agreed, and at the last moment, the Supreme Court turned it down. And over £1 billion had been reclaimed before then. I've been heavily involved in it. You can hear I'm party pre by the way I'm talking. And then we were shut down by the big institutions of state, effectively. And so this, and what Ollie's done, and also the fact that he's planning to appeal it to try and give it broader range, even though he's got the money himself, is a wonderful campaigning act. It's quite generous of him. You're effectively risking the money so that you're not going to have it in your pocket to try and make this ruling apply to more people.
Okay, let's hear from Kate Briscoe, Ollie's solicitor. Kate, what was the plan of action? What was the opening that you espied that you thought might make Ollie's case different?
Well, I'd been working, towards finding a solution to bank charges for some years. It had become a bit of an obsession, I have to admit, and working with Tom Brennan, our barrister.
You'll get on well with Martin then.
Indeed. And yes, I was working with Tom Brennan, an independent barrister who keeps his finger on the pulse of judgments coming out of Europe. And this amazing Hatterslag ruling came before us, and we realised it had huge significance. And so it was merely a case of spotting Ollie's case on the LegalBeagles forum and seeing that it had real potential, and he'd been very brave taking it forward himself. And he had a court hearing coming up, and we stepped in and took over the case.
Yeah, it sounds like from Ollie that there's nothing really massively different and unique about him. You hear these cases the whole time. You hear about people this the whole time. So, I mean, it's kind of normal, isn't it? What's happened to him?
This is the crucial thing, and this is also why Ollie is appealing, because his case is not that unusual. It's very, very classic and typical of lots of people who get trapped in a cycle of debt with these charges. And that's why, he has made this very selfless decision to push forward.
Now, let's just give a bit of background to people who may be in a similar position right now. The first thing is, while the door was shut on mainstream bank charges in 2009, it wasn't shut on financial hardship bank charges. And so still, if you have I'm going to simplify this for speed. But if you have financial hardship where your charges were a considerable causal factor, i.e. the reason you're in hardship was because your charges pushed you there, then you have still been able to reclaim from the financial ombudsman. And in fact, we regularly get wins from the financial ombudsman, £2,000, £3,000, £4,000 of people who's had charges on charges, and that was the cause. Now, you went to the ombudsman, you got a partial judgment, didn't you, I believe?
No, they turned down my case on the basis that Lloyds had refunded me partial charges up to the point that they believed that I was in financial hardship. Although I'd been telling them before that point, it was at the point I instructed a debt management company to assist me in bringing the situation forward. And basically what the judge said was that actually Lloyds should have recognised I was in financial hardship before that.
So Ollie went through the ombudsman process, but only to the adjudicator level, and then you moved it to the courts. Now, where this gets really interesting for me, and we're all sort of, there's conversations going on behind the back of those of us who campaigned on bank charges about this, is the question is, does this actually have wider reach beyond financial hardship? Because it is possible that you can interpret the first question. Everybody always looked for was a rule that said bank charges had to be fair. That was the question, never been about whether they are fair or not, but whether they had to be fair. And this looks like it may have opened the door there. And so we're now trying to work out exactly what this means. It's worth remembering it's only a county court judgment. So while it doesn't set a legal precedent, but it does set a sort of a natural parlance precedent that some judges are willing to look at this again. So the potential impact of this is monumental. We are talking billions of pounds.
Well, I've got a text in here, Martin. Stephen in Dorset's just texted in the last 10 seconds. This is my situation too. Halifax have made a fortune off me in overdraft fees over the last 3 years after losing my job. Do I have a case? Obviously, this is a tweet and we can't judge a case off a tweet, but...
In your case, what I would suggest you do is make a formal complaint under the financial hardship bank charges rules. You can find information on the internet on how to do it. Put that into your bank. They will probably reject you, then take them to the ombudsman. The step that Ollie did, which I wouldn't necessarily say that everybody should be doing, is taking it to court. Now, Ollie is a pioneer. And what we are waiting to see is, does Kate's appeal, will they get the appeal to go through so that we can get a precedent on this? Where will we take it forward? So the jury is out on this. Sorry, terrible phrase to talk about a legal case. But effectively at the moment, we're watching, and I think we need to let Ollie be the pioneer. And I think you're happy to do that, aren't you?
Let's hear Ollie. What's next?
Well, I'll be looking for Kate's and Tom's opinion on this. But as far as I'm concerned, I've been in that situation myself where you spiral out of control, and actually that's not fair. That needs to change. So I will be taking this forward as far as I possibly can.
But for anyone in this position now, well, I'm not saying don't do anything. Make a formal complaint to your bank and take it to the ombudsman. You may just want to think twice about going to court. I think we should let Ollie's case play out, hopefully set a precedent, and after that point, it's something on my list. I've got plans to call the head of the FCA to discuss this, and try and think, how can we get this action done so that individuals don't need to do it itself? If that's what the law says it must be fair, then let's reopen this, rekindle this, and get this going again. And Kate and Ollie and Tom Brennan have done a brilliant job on sort of lighting the fire under this. And we need to see if, I'm more than happy to try and blow some flames on it, blow some air on it to make flames, whatever the fire
That's
analogy
something
is.
I'd pay to watch. I'd pay good money to see that, Martin.
Okay.
Kate, very quickly, this is something that you feel isn't just for people in financial hardship. You reckon this can go wider?
Yeah, we certainly do. We've looked into it. It is purely and simply that if a term is unfair, it is unfair, and it doesn't really matter whether you're in hardship or not. This is about making the banks sit up and realise that this method of generating revenue from people's punishing them when they're in tricky times, not just continuing hardship, but just making life extremely difficult for them, is not a suitable or sensible way to derive your profits going forward.
The idea is that the charges are disproportional to the cost to them, and effectively what we've always had is a cross-subsidy from the poorest in the society to the richest in society. It does cause shockwaves. One thing I will say on the bank sides on this, when we first started, I think I first wrote about bank charge reclaiming in 2005. 6 million of my template letters were done in the intervening years. This was enormous. Back then, you went £2 over, it was £35 a transaction. So there was a classic case of a woman who, so for people who are saying it's your own fault, she had written a cheque 7 weeks earlier to a friend. That friend hadn't been going to cash it, then changed their mind. They cashed that cheque. This pushed the woman into beyond her overdraft limit without her having checked the bank that morning. OK, we might argue that's a fault. She hadn't checked the bank. She went shopping. She bought 7 items totalling £40-ish on her card. Each of those 7 items, she got a £35 transaction charge. So that's about 250 quid for £35 worth of shopping. She never recovered. A year later, she's £2,000 to £3,000 in debt because of charges on the charges. That is entrapment. That has got better because most of the banks have now shifted to £5-10 per day charges. Still not great, but bank charges did provide a social good because it got rid of the hideous per transaction charges and got us now to the only horrible per day charges.
Good stuff. Thank you very much, Martin. Ollie, Kate, please do keep us up to date about what happens. But it sounds like if you're successful, we could have Bank Charges, the sequel. And that's a story that we will definitely follow. Lloyds have given us a statement. The judgment states, Lloyds says, that Lloyds Bank has until Thursday, the 18th of September, to make a decision. At the moment, the bank is still considering its response to the judgment. Until the time that we have made a decision, I imagine, on whether to appeal, I'm afraid it would be inappropriate for us to comment any further. Just a news line just in the last few minutes. The jury in the sex abuse trial of the former BBC broadcaster Dave Lee Travis has retired to consider its verdicts. Dave Lee Travis, whose real name is David Griffin, denies indecently assaulting 2 women in the 1990s and a third in 2008. Martin, we've had a few texts just come in on this, and we'll chat to you after the news and sport. But first, time for some news with Faye. Someone who's not afraid of making a scene is Martin Lewis, who's with us on the consumer team as he always is on Thursday. Martin, we've had quite a lot coming in on this bank charges story, and I think a lot of the texts relate to this sort of why has this come back type of theme. James in Bath: I originally tried to claim back bank charges back in 2008, was stalled by my bank sending me incorrect statements. The bank charges I was attempting to claim back stretched backwards to 2003. Does this new ruling have any implications for my case? What do you think?
Not yet.
Not yet.
And that's a very deliberate answer. This new ruling is the door having gone from slammed shut to someone has just put their foot in it, but it is not open yet. And what we have to do is look at what happens with Ollie and his case going forward. If you are in financial hardship or have been in financial hardship and that was caused by your bank charges, the door has always been open, even since the 2009 ruling. And as I said before, there's information available for you to get your money back, and I regularly get successes of people getting their money back from an ombudsman ruling. But to actually the mainstream idea of bank charges in themselves being unfair, both current bank charges and, more importantly, past bank charges where they definitely were unfair. We knew how disproportionate they were, just the law didn't say they had to be. That's what this is all about.
Yeah, because the funny thing is that loads of people were claiming successfully, weren't they? The OFT, in its wisdom, decided to take it on, gather all the cases up, and then lost.
Well, the last thing we ever wanted was a precedent. So when I was involved, very heavily involved in this, as you know, and what happened is you took the bank to court and they paid. So if you had bank charges, they gave you your money back. And the banks didn't want a precedent set on it. We weren't that keen to have a precedent set because, you know, in realpolitik, people were getting their money back. And £1 billion was paid back. The OFT took it, and it took the case. Now, what the OFT did, to get really slightly complex on it, it took one element of law and it took the case on that one element of law, saying bank charges were unfair under this law, and the Supreme Court on a technicality said that law doesn't apply to bank charges, not that the bank charges were fair. Now, straight after that, having been involved in it, I actually put money aside, quite a large sum of money, to pay a barrister to get an opinion on other points of law that we had always argued could have been looked at this. And that opinion was very strong. It said, well, the bank charges don't have to be fair under that particular part of the UTCCR, but they do under this bit and this bit and this bit. And I went back to the Office of Fair Trading and said, will you take the case back on? And what they said at the time is, we don't believe it's in public interest. In other words, they got burnt because they lost, and they didn't want their reputation to be at risk by taking it back to court under other rulings.
And that follows on to a text from Colin in Doncaster, which says, does Martin feel that the Supreme Court let the banks off the hook over punitive charges because it came just after the banks started collapsing in late 2008 and felt sorry for them, as I do, said Colin. I mean,
no.
do you think there was that judgment not in the public interest because the banks were on their knees?
No, I think the judgment was made on a point of law. It's a point of law I disagree with, but I don't believe the Supreme Court were biased in order towards the bank because of what was going on.
Was that their explanation?
However, I do believe that the general willingness of politicians and the institutions of state not to look at other ways that this was unfair was because of what was going on at the bank. So it wasn't the Supreme Court, which is justice is blind, and I do believe it was blind. I think it was also blinkered, but it was blind and fair at the time. But I believe the fact that nobody wanted to look at these other very strong avenues afterwards was because of the collapse of the bank. So it's a nuanced difference between what the person is suggesting and what I'm saying, but quite an important one, I think.
Two more quick questions on this, and the thing that a lot of people complain about is often just about transparency, isn't it? And Dave in Leeds has texted in saying, can you please explain exactly what it costs a bank if someone goes over their overdraft limit? If we knew that, then the courts could stop this extortion. That's an interesting point.
No, it isn't. I'm afraid it isn't. I don't mean to be rude, but we know what it costs them. We did all this research. We had really authoritative research back that it basically costs a couple of quid and they charge you 30